We have court Wednesday, correct?
I mean, we're scheduled to have court on Wednesday. No, for the whole day.
They're going to deliberate the day before Thanksgiving? All signs are pointing to a rushed verdict here.
I'm denying the motion for directed verdict on all counts, except I'm granting a motion for directed verdict as to count 59, count 60, and count 62. Yeah, I know you think that. So thank you. What does the defense think?
I'm just not entirely clear what participate in the enterprise means.
Yeah, me either, but that's the way the statute's written.
That sums up today.
Going home, talking over the Thanksgiving dinner. You hope that they don't, but you don't know what
Well, I'm instructing them not to, and whether they have gotten the case or not, they're not supposed to be doing that.
I agree.
And
They're going to talk about it at Thanksgiving, bro. I'm telling you. The YSL RICO trial is nearing the end. Defense attorneys present motions for directed verdict, which Judge Whitaker partially grants. Jury instructions for this giant case is then hashed out and very confusing. So it looks like closing arguments is going to start on Monday, and the jury will be deliberating the day before Thanksgiving on Wednesday for one day and then have a full weekend. So there's a chance there could be a verdict on Wednesday, the day before, if they rush the verdict, because all of them are like, yo, let's get this shit over with. Let's go to Thanksgiving, get the hell out of here. Of course, this trial ends with the timing of a national holiday that everyone loves, and you can eat all the food you want. There's actually a lot of funny moments today, so stick around, hit subscribe. Here we go, boys. So both Doug Weinstein and Max Sharp filed a motion for directed verdicts. It's basically a request asking the judge to rule in their favor, arguing that the evidence presented by the state, there's no legally sufficient evidentiary basis for a reasonable jury to reach a different conclusion. So it's like taking away the jury having to decide on those counts. So the judge is going to have to decide if there was good enough evidence to convict them on those counts. And I'm guessing it's going to be about mainly the drugs and weapons.
is there a separate one for Mr. Stillwell? Or you?
Mr. Sharp and I last night went through a number of the predicate acts and overt acts that are in the indictment. We've kind of made a detailed list of those predicate acts that we do not believe have been presented at trial. We're moving for a directed verdict on each of the counts against Mr. Kendrick, counts 1, 2, 50, and 57 through 63.
So they're doing it also for RICO counts.
Also moving for a directed verdict as to those overt acts that are before the 5-year date, before May 10th of 2017 in the indictment. Jury is going to have to find at least one overt act that occurred after May 10th of 2017.
Right.
So I believe it would just be extra work for the jury and potential confusion if they were to sit there and go through each of the overt acts before May 10th, 2017. I understand that the state is allowed to put those into the indictment for a number of reasons. I understand that they like them in, or they want them in there in order to be able to quote unquote tell the whole story of the alleged racketeering activity. But since none of those overt acts can be used to support the any racketeering conviction, I don't believe that those overt acts prior to May 10th, 2017 should be before the jury for a decision.
Brian Steele said this: if the overt act is before May 10th, 2017, they can't be used to convict.
I don't believe the state has shown evidence upon which a rational trier of fact could find an overarching conspiracy seeking to achieve an overall common goal as required by the law. The state has shown a number, quite a few, I would agree, a number of individual acts they've presented. They have presented a number of crimes and alleged crimes committed by co-conspirators, but I do not believe that they have presented to this jury any form of an overarching conspiracy that would tie those acts together.
A lot of the overt acts are impossible to tie together because they aren't related. They're just thrown in there. There's several. So Doug Weinstein's pretty much shitting on the state here, saying their evidence wasn't good enough for certain overt acts.
Don't believe that the state has presented to the jury an enterprise that would be required, at least a criminal enterprise. I do appreciate that perhaps they don't have to show that the enterprise was criminal in nature, so I'm not going to spend a lot of time on that. A pattern of racketeering activity is required for the RICO. This pattern, as you know, requires two predicate acts. They have to be within 4 years of each other. And the key that I want to focus on is that these acts have to be interrelated. And it's the interrelated portion of the statute that the state has not shown for the jury, and that a rational trier of fact could not find. Again, after watching this trial for a year, it's clear that the state has put on evidence of various crimes and alleged crimes. They've put on witnesses. They've had testimony from individuals that are alleged members of this conspiracy that have taken the stand and admitted to committing particular crimes. But they haven't shown at all that these crimes are interrelated. In fact, when the witnesses have taken the stand and they've been questioned, in response to questioning, they stated
60% of you aren't subscribed. Come on, hit the subscribe bell.
I believe they stated universally that they committed these crimes for themselves. If they sold drugs at a gas station, it was to get money for themselves. If they robbed somebody, it was to get money for themselves. There's been no demonstration that this was interrelated at all.
Especially financially. The judge is not going to do this for the RICO count, though. She's going to let the RICO count stay.
And they could have attempted to show that. They could have subpoenaed financial records. They didn't do any of that. If they just show a tremendous number of different acts, that's sufficient. And it simply is not sufficient. They can try to argue interrelatedness, and I am sure that they will, but they haven't demonstrated that for the jury, such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac. And inside of the Texaco station, this Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti.
I mean, he's making great points. She's not going to change anything about the murder counts. She's not doing nothing with those. Ain't no way. She's going to let the jury decide on those.
I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? Interviews that various individuals gave with law enforcement. I believe they have interviews that they presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have interviews. They have the plea agreement from Mr. Sledge. And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. In the case with each of those witnesses, when they've gotten on the stand, but Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Shart so desperately wants to bring into the court and show to the jury.
Rightfully so. Rice Street is actually hell.
He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas. Last, Your Honor, counts 57 through 63. All of those counts relate to the activity, the raid on Jeffrey Williams' house on May 9th, 2022. Each of those counts is either specifically a gun count or a drug count, or they're predicated on a gun count or a drug count.
She could grant the directed verdict for these counts because there's literally not much evidence connecting him to any of the guns or drugs in Thug's house.
There has been zero evidence of Mr. Kendrick in actual possession of those guns or drugs. I'm sure the state will argue that he was in constructive possession, and I'm assuming they're going to argue this because they have two pictures from Mr. Kendrick's phone that were on his phone, that were modified on his phone on May the 9th of 2022. There's been no testimony presented that those pictures were taken by Mr. Kendrick. The only evidence that has been presented is that those pictures are of the inside of the house. Let's assume he's inside the house, even if you want to make that assumption. There's been no evidence of constructive possession because there's been no evidence presented of any intent or ability or intent of Mr. Kendrick to exercise control of either the drugs or guns in that house. Zero on intent and zero on his ability to access those weapons and drugs. Count 63 is the 133 charge against Mr. Kendrick. As we discussed previously in court, there's an essential element of 133 that has been left out. So I believe a directed verdict on 133 on that count would be appropriate.
Let me interject and ask you, I saw that Mr. Abadi had sent something that addressed whether, even if the directed verdict is appropriate on that, a lesser included. Can you address that?
Sure. I saw the one specific case that I saw that would support Mr. Abadi's position was Martinez v. State, 318 Georgia Appeals 254. That case, I cannot find a single other case that follows that case. Again, to be candid with the court, I don't see any case that says that case is wrong. But I would argue that the 131 count should not be charged to the jury, that the motives of charging 133 versus 131 is that 133 carries significantly higher penalties, and that they put in 133 in order to have greater leverage in plea negotiations. And I don't think after having used that leverage for the past 2 years, that they should now that they can't prove up the 133, should be allowed to reduce it to the 131. But I cannot argue right now before you that Martinez does not support the state's position, Your Honor. And then again, I'm going to adopt whatever arguments that Mr. Shart is about to make on behalf of his client that would also apply to Mr. Kendrick.
All right, Max's turn.
Mr. Stillwell and Mr. Kendrick, to be guilty of count one, the jury, under the law, would have to find Mr. Kendrick and or Mr. Stillwell joined the conspiracy knowingly and willingly. I'm going to ask Your Honor to consider the Cotman case, COTMAN v. State, 342 Georgia Appeals 569. It was a conspiracy to commit RICO case.
Doug Weinstein looking a little uncomfortable. I think he needs to buy some clothes from publicrec.com/CUFBOYS. I just received this package a day ago. When I tell you that something is high quality, it's high quality. This knitted sweater and these pants are the real deal, boys. The real deal. You can tell someone actually put effort in the quality of this brand. Nothing stiff or tight or uncomfortable that you have to wear out. Like, you can wear this anywhere, bro. It's so sick. And you know what's really a game changer? The Game Changer pants. These look like your regular office pants to other people, but they're actually so comfortable. You can wear this to work, to parties, any type of event, or if you're out and about with your friends or family. The Game Changer pants are the perfect choice for blending style and comfort. They're like stretchy, but they don't feel cheap. They feel like incredible. It's so weird. They have all the different colors and sizing options, so it literally will feel like it's tailor fitted to you. And don't even get me started about this waffle knit hoodie. Ladies, if you're watching this hoodie might be the perfect gift along with the Game Changer pants. I mean, this thing is made with thermal waffle knit fabric that just feels absolutely insane. Stop suffering in regular pants and give the gift of comfort this holiday season. For a limited time only, shop their holiday sale and get 25% off at publicrec.com/CUFBOYS. That's publicrec.com to unlock the best savings of the year. After you purchase, they'll ask you where you heard from them. Please support our show and tell them where you found them. That'd be really cool. Give yourself or someone you love the gift of comfort. It's absolutely insane. Trust me. I don't promote anything that's terrible quality. It's some good stuff. publicrec.com/CUFBOYS. Go get it. Thanks for support.
The indictment for count 1 is missing an essential element that has been required by the case law, that has not been required by statute, but is required by the case law. And because that knowingly and willfully requirement, that mens rea requirement, is missing from the indictment, count 1 is subject to a directed verdict, a general demurrer and directed verdict, as it applies to both Mr. Stillwell and Mr. Kendrick. Someone associated with the gang committing one of the specified crimes under the Gang Act. Additionally, Your Honor, they added, to save the statute constitutionally, the Rodriguez court added the requirement that the alleged illegal act must be in furtherance of the gang. On this indictment returned by the grand jury, alleged that the act committed was in furtherance of the gang. Now, we know that that must be proven. The jury charges that we're going to give the jury list in furtherance of the gang as an essential element of this crime. And it is absent in all of the Gang Act violations alleged in this indictment.
The judge ain't gonna agree with this.
The indictment for those counts does not allege every essential element of the crime. Those counts are subject to a general demurrer and a directed verdict as well. The only evidence against Mr. Stillwell, there's no cell phone evidence. There's nothing of that nature. There's no identifications from the scene. The only evidence are social media posts and the testimony of, well, not the testimony, the out-of-court statements by two individuals, one being Quindarius Zachary, who completely disowned what he said, and back in the interviews when he was under the pressure of incarceration, under the pressure of prosecution. And we pointed out, hopefully effectively, that Mr. Zachary's story about this confession changed in material ways when he told the story in 2015 to when he told the story in 2017.
I mean, yeah, they did discredit Quindarius and Woody pretty significantly.
Mr. Copeland, I mean, you were here for that. He made out-of-court statements under the pressure of incarceration. He's openly admitted he would have said anything to get out of jail, to avoid prosecution, to avoid Rice Street, and not even that he witnessed anything, but he was told something by someone else who did not testify. As far as I can tell, the entire universe of the evidence against Mr. Stillwell, and our argument is that it doesn't clear that hurdle of surviving directed verdict. My reading and my argument is that Part 3 is essentially a list of overt acts. That's what it is.
Yeah.
And we are all of the same opinion. We're giving the jurors a jury instruction. It's clear, it's in the statute, that the statute of limitations for the overt acts is 5 years before the date of indictment. And that's going to be, my understanding, that's going to be charged to the jury. So I do not understand if they only need one overt act, okay? And that overt act has to be within 5 years of the date of indictment. All of these other alleged overt acts that can't count, can't be used, and are completely not needed. I could see a situation, for instance, if they needed to show two overt acts, and one had to be within 5 years of the indictment, but one didn't, okay? It was just the last one needed to be within 5 years, but they needed to show two. I could see the need for all of these other allegations. That's not the case. They need to prove one, according to their arguments, and it has to be within 5 years of the indictment. So everything that predates that cutoff date, which I think would be May 10th of 2017, it can't be used to convict.
It's not sufficient.
Well, but it doesn't add anything either, because you only need one.
Well, they also have to prove a conspiracy and an enterprise, and so
They do have to prove a conspiracy and enterprise, and I'm not argue about these things in closing. I'm not, I never argue that they couldn't get into these things. They shouldn't be alleged in the indictment going back to the jury, because we're telling the jury, we're sending the jury a completely mixed message. We're saying you can't find an overt act that...
We're not saying that. We're not saying you can't find an overt act before the 5 years. What I will be saying is it is necessary if you want to convict.
Right.
That you find, or if you believe there is evidence sufficient to convict, part of that evidence has to be an overt act within 5 years.
What an absolute shit show, dude. This RICO statute is just so... The evidence has to be an overt act within 5 years. Then why were we on 2015 for so long?
If they find an overt act within 5 years, that is legally sufficient
Correct.
to authorize a conviction, which would make all of these other...
I hear what both of y'all are saying on that, and I just don't think I'm convinced that it should not even be presented to the jury because it's not sufficient in and of itself.
Told you. She's being real careful about the RICO side of things.
Does the state acknowledge that there are maybe at least some overt acts that no evidence was presented on?
Yes, Your Honor, and we don't intend to have that go back to the jury, and so we can discuss with defense
All
counsel.
right, I can certainly let y'all.
Yikes. How embarrassing. The state admitting no evidence was presented for some overt acts. And that's because they had to rush this trial and everything, and patience was running thin in the jury and plea deals and everything, but still an L.
The Shamal Drinks alleged murder, I think the video speaks for itself. I don't believe that there's sufficient evidence that would authorize a rational juror to come back with a guilty verdict. You know, we heard from Dr. Stanley, the ME. Mr. Abate asked if someone's foot could stay on the brake, and she acknowledged that a foot could come on the brake and stay on the brake after being shot in the neck. And I asked, what about lifting the foot off the brake and putting it back down? And she said that would be an impossibility.
The state is alleging Shamel Drinks was shot by Shannon. Shannon pulls off. Other car pulls up. When the other car's near him, his foot comes off and then hits the brake again. That's literally what happens on camera. She said it was impossible. She's not going to change anything about the Shamel Drinks murder. There's no way.
I'd have to review my notes, but I'm going to say it was about 26 seconds, I believe, between when his car left and when that brake light on Mr. Drinks' car was going on and off. Additionally, we have the U-turn. Additionally, we have the negative gunshot residue test. We have no muzzle flash. It seems to me that we would have a muzzle flash. If we don't have a muzzle flash, the logical conclusion would be the shot was fired from inside the car. We have a negative gunshot residue. I'm not going to argue that there's not evidence that could survive a directed verdict. You know, we've heard it was the gun that was found on Meadowlark was registered to Taisha Alexander. We've heard Taisha Alexander is Mr. Stillwell's girlfriend at the time. But I will adopt Mr. Weinstein's arguments. This was indicted as 16-11-133. We were put on notice for 133. It's missing an essential element, and we're going to argue that the state should not be able to alter, on the eve of closing arguments, alter the charges. And also, I'm not even sure about the mechanics of how that would happen at this point.
I mean, that's their argument is, yeah, we may not have the elements, and they certainly don't have the elements for 133, but we have the elements for 131, and that's what should get charged instead.
They put us on notice to defend against 133, and they left out an essential element, and now we're changing the charges on the eve of closing argument.
I mean, it's great points. Changing the charges on the eve of closing arguments is kind of...
Your Honor,
Oh no, Mr. Atkins is about to yap, dude. This guy is he's smart. Mr. Atkins is clearly a very smart guy, but boy does he yap, dude.
the state believes that there has been ample evidence that a rational juror could find that they conspired to commit at least a pattern of racketeering activity. And obviously, defense counsel has focused on the money or proceeds. The state believes that for purposes of directed verdict,
Through a RICO conspiracy, and y'all only have to prove one, you don't have to prove both.
Correct,
So
Your
you're
Honor.
saying there's at least evidence as to the overall purposes, Part B of RICO.
Correct, Your Honor.
See, you can just tell by her attitude. They're going to be lucky if she grants any of the directed verdict motions.
Those are just 3 to start. You also have tattoos, which are permanent. And so Mr. Kendricks has slat on his left forearm and a large snake that was introduced, I believe yesterday or day before, on his stomach that goes up to his neck. You have defendant Stillwell, multiple admitted exhibits in post that reference slime or reference his, for example, Exhibit 430 VV is defendant Kendrick, overt act 133 with a red bandana and a YSL pendant.
So you're just pointing out tattoos and clothes and everything that associates everyone with YSL.
Is defendant Kendrick with a hat with a rat crossed out on it. State's Exhibit 38, November is overt act 134, where you have Kendrick pointing at the cameraman, 2 individuals with Make America Slime Again. And I could go on, but the point being, you have both 2015 exhibits where Detective Gaither and Detective Dennis, you had Twitters of Mr. Sledge, you had Twitters of Mr. Zachary, Twitters of defendant Stillwell, where actively and openly possess my slimes, YSL, this is my brew. And that allegiance coupled with the evidence at trial of the murder of Donovan Thomas to begin with, which captures overt acts 16 through 20, which the evidence of that murder from the interview statement of Kenneth Copeland on June 10, 2015, and Quindarius Zachary on August 15, 2015. Quindarius Zachary's interview, which was played for the jury and is in evidence, states that defendant Kendrick and Stillwell confessed to him that very night. And defendant Williams Kondo, who rented the Hertz rental vehicle that the Infinity rep, all of those things combined that statement of Copeland and Zachary for the why it is a criminal enterprise murder. There's no personal disagreement between Mr. Thomas, Mr. Kendrick, Mr. Stillwell, and Shamel Drinks. You have four, at least defendant Stillwell, Mr. Garlington in the white Audi, defendant Nichols and Miles Farley in the white Ford Fusion. On the April 28th, 2015, which was Demekion and Garlington getting jumped at Club Crucial, there's a 911 call around 2 o'clock a.m. Fast forward, you have two shootings at 1903 Drew Drive and 1428 Adele. You had testimony from Ms. Bell, whose home was shot, technicians and responding officers, and you had in the interview and testimony of Zachary and Sledge, that act in concert, which was only 3 months after the murder of Donovan Thomas, shooting at, intending to strike rival opposition members, the ABG, Inglewood family, YFN, that group. So from January 10th, 2015 to March 14th, 2022 of the murder of Shamel Drinks, the targeted acts of violence in concert by YSL members is towards the same opposition group. Although the state did not allege actual commission of racketeering activity, gives clarity that this conspiracy was not some fanciful idea. It was actually alive and well. The best evidence of a conspiracy in a group, as a number of other factors, and I would not rattle off all of these cases that are other factors the court looks to an enterprise, gang and hand signs. There's been evidence admitted in testimony from APD gang detectives of the quintessential YSL hand sign, the wiping of the nose, greeting phrases the court has heard and seen in text messages and wiretaps, slat and slime.
Why don't you move on beyond
Yes,
enterprise to some of the other necessary elements?
Yes, Your Honor.
Thank you. She's like, I get it. Let's get more than just the enterprise and association and the colors and hand signs and shit.
Both association with YSL members and active promotion through either of that criminal street gang through their own words or social media of showing allegiance to that, posting with YSL pennants.
So he's saying posts and tattoos are them joining in on the conspiracy.
Using the common gang identifiers and hand signs and with other YSL members throughout from 2015 to as recently as 2022 shows, and the commission of the racketeering activity shows that they were a part of it. As in, you do not need, of course, a written contract. You do not need, of course, some videotaped roundtable of discussion. Their actions speak louder than words. And so if you need to, there's ample evidence a rational juror could find that because of the commission of murder, aggravated assault, and continued association, that they have actively agreed to be a part of this enterprise through their very own actions, willing to either assist or actively participate in racketeering activity.
What if it was just a group of nice young men making music, posting YSL? I'm just joking.
Call was presented of Christian Eppinger, who was in the jail, calling him saying, I'm on PC with that boy Lucci. How much can I get for that? Then you have the text messages that were the color-coded charts that Viverito walked through with Khalif Adams, Demekion Garlington, and Jaden Myrick. Then you have the video that from the jail where Jaden Myrick, after that messages about stabbing YFN Lucci through the testimony of Viverito of what they were discussing, actively tried to stab YFN Lucci. Then you have the post of defendant Kendrick predating that, but 2019, I believe, standing on top of YFN Lucci's.
Right, but I mean, a post isn't an act of racketeering. So talk about.
Yes, Your Honor. So you have multiple YSL gang members, all of which, I use that example because I believe it's so salient, of multiple actors, multiple ages, multiple years in time. It's the same individual that they're trying to exact violence on, who happens to be the same individual who was very close with Donovan Thomas in 2015. All of those.
Under Georgia's RICO law, every religious faith and every political organization and most police departments and prosecutors' offices are a criminal conspiracy. You don't have to or be aware of any wrongdoing to be liable. Have members of the Catholic Church committed 2 or more crimes? So imagine a prosecutor says there's a Catholic RICO conspiracy to distribute obscene materials because some porn actors are Catholic. Some of those proceeds go to the church. You are a volunteer at your church and you want to use some of the money in that collection plate to build a new vestibule. Well, now you are conspiring to use the proceeds of racketeering to allow the church to acquire something of value. So in Fulton County, for instance, went after a bunch of school teachers for cheating in the APS RICO case. They did not have to establish the teachers actually cheated or helped anyone cheated or gained anything by cheating. It is a crime with no actual elements. Georgia's RICO statute is so broad that I'm genuinely unsure of whether a juror who acquitted someone for RICO could be charged with RICO. All right, this is, I think his name's John Floyd. He's apparently the person the state brought in as like the RICO specialist for jury instruction and all this shit. So this guy must know a lot about RICO trials and everything.
If I understand correctly, an argument that there's not sufficient evidence for the jury to find the defendants acted knowingly and willfully, and that is clearly present.
Oh, no. I think we're interweaving
I'm sorry,
different
then.
issues now. I thought you were moving on to the issue of whether overt acts that aren't within the 5 years.
If I understand the logic chain from the defense, it is basically we only have to prove one overt act within 5 years of the day of the indictment. Therefore, Anything else is, I think the term was used, surplusage. That doesn't fit the definition of surplusage. And then with particular emphasis, they've said if it's outside of that 5-year window and then would not be relevant to prove the timeliness of the indictment, that then particularly the jury shouldn't hear it because it's confusing, et cetera. I'm aware of no case that has accepted that argument, and it shouldn't be accepted because the allegations are relevant. They show the existence of the enterprise.
Bro is yapping.
The people who participate in them continue to acknowledge their existence. That is certainly relevant, and there's not an arbitrary cutoff where the indictment gets trimmed to match the statute of limitations. I'm just not personally aware of any case that's ever done that.
Well, just because you're not personally aware of any case don't mean there ain't one out there. All right, Ms. Hilton coming up.
Your Honor, we have presented evidence of the June 10th, 2015 video recorded interview of Mr. Kenneth Copeland at the Atlanta Police Department.
Isn't that crazy? She brings up the Donovan Thomas murder and instantly goes into Woody snitching on camera. That's how they proved the Donovan Thomas murder was committed by Yak Gotti and Shannon and everyone else.
That video, Your Honor, Mr. Copeland discusses a co-conspirator statement of Demekion Garlington, in which Demekion Garlington tells him about the murder of Donovan Thomas, that who was involved, which was Mr. Stillwell, Mr. Kendrick.
Are snitching interviews sufficient evidence for you to put someone in jail, like someone just speaking?
In that interview, Mr. Copeland speaks of his whereabouts on the day of the murder of Donovan Thomas, beginning on early in the morning hours and when he eventually meets up with Mr. Garlington at a gas station on Cleveland Avenue. He further tells the detectives that Mr. Garlington told him that those 4 individuals, again, Mr. Stillwell, Mr. Kendrick, Mr. Cobb, and Mr. McMullen, had committed the homicide of Donovan Thomas Jr. He told them about the type of car that they were in, which was an Infiniti vehicle, the location of where Mr. Donovan Thomas was, which was the barbershop on 330 McDaniel Street. We then also introduced the August 2015 statement of Quindarius Zachary, which Mr. Zachary corroborated some of the same information that Kenneth Copeland provided. He also added the additional information or evidence in that interview, which was Mr. Stillwell and Mr. Kendrick at the condo of Jeffrey Williams confessed to him that they had participated in the murder of Donovan Thomas Jr. Donovan Thomas Jr. outside the barbershop moments before a silver and color vehicle, which was identified in testimony as an Infiniti, drove down the street. And
was it identified as an Infiniti? I thought they were like, we can't really see the logo. It just looks like a silver car. Someone confirmed that was a silver Infiniti in the video?
We also have the Texaco surveillance video, which corroborated Mr. Kenneth Copeland's statement. In his statement, Mr. Copeland tells officers that Demekion Garlington told him that they met at the Texaco gas station, that they switched cars, which he explained that Mr. Kendrick initially arrived in a Pontiac Bonneville, and that the gray Infiniti vehicle met at the Texaco gas station. That was depicted on the surveillance video. In the surveillance video, you see Mr. Kendrick walk into the gas station. You see Mr. Kendrick approach a silver Infiniti vehicle. You see both of those vehicles leave out of that gas station at the same time, which was the rental agreement from Hertz Rental, which showed that the vehicle was rented by Mr. Williams 2 days before the homicide of Mr. Donovan Thomas Jr. We then also have phone records that corroborated what Mr. Copeland said. We have the phone records that show that when Mr. Copeland woke up, when the morning hours, or the afternoon hours, of January 10th, 2015, he was located. He told police he was at his girlfriend's home, which was in the village of Carver Homes. The phone records corroborated that his phone was at that location at that time.
You see how literally 99% of this is about what Woody said?
There is a number of different phone calls to a variety of different people, specifically an individual by the name of Kelvin Treadwell, OG Bentley. Both Mr. Copeland and Mr. Zachary in their statements advised that after the murder of Donovan Thomas, the guns in the vehicle were given to Kelvin Treadwell, also known as OG Bentley. The phone records corroborate that a number of different phones, Mr. Williams' phone, Mr. McMullen's phone, all ping in the location in and around near Kelvin Treadwell's home after the murder. Little D was the nickname for Quindarius Zachary. And what Mr. Stillwell said during that call is, they snitched on me. And I'm paraphrasing. It was never, they lied on me. It was never.
She's going to let the jury decide all the murder shit. I've said that several times already, but that's not getting changed.
Stillwell has, which was called BS or bullshit. And in that song, he says, beat the hom, no evidence. We believe that is another reference to the murder of Donovan Thomas. We also have Stacey Exhibit 436 VV, which is Mr. Stillwell after, in 2019, posting a picture with himself in a slime sweatshirt with the peanut gravestone in Spanish, then immediately deleting that from his from that Instagram post within a few minutes after posting it, Your Honor. So we believe that there is sufficient evidence for the jury for a rational trier of fact to be able to find the essential elements of the crime beyond a reasonable doubt. From Mr. Stillwell, and I believe this post is on March 11th or maybe March 12th, that says, just rest Mac, I got you. Then we also have a post, which is 458 VV, that is posted on March 11th with Mr. Stillwell posting, I ain't gonna be the only one crying. On March 15th, 2022, we have Scarface, who is, we believe, in the car with Mr. Stillwell at the time that the murder takes place, posting a picture of both Mr. McMiller and Mr. Ford saying, "We got y'all boys." And that is only hours after the death and murder of Mr. Shamel Drinks. We then also introduced, Your Honor, the rental car agreement, which showed that Mr. Stillwell rented this vehicle on March 14th, 2022. And then we also have the wiretap information that shows that he went to a tinted window car place and got deep tints on this car on the day that this occurs, Your Honor. And then we have text messages while in January of 2022 saying that he goes op hunting. That evidence is evidence that a rational trier of fact could find the essential elements of the crime of murder beyond a reasonable doubt.
So she's going through a lot of stuff, posts, anything that ties him to YSL and the murders, everything, which is what she's supposed to do. This is her job. I wonder what the judge going to do here. I may say the lyric about a drop top, hanging out the top of a drop top or something. A sunroof ain't considered a drop top. I thought that was like a completely convertible car. It's a drop top.
Before you do the gang counts, can you address the 58 through 61 drugs and machine gun and whether there's evidence of constructive possession for Mr. Kendrick?
So it's regarding Mr. Kendrick, Your Honor, there is evidence that we know from his phone that he had been at the home earlier that day. We know that based on testimony from Officer Samba that he fled from the home.
No, he was okay.
And apprehended, Your Honor. And we believe that that would be some evidence of consciousness of guilt, the fact that he fled before the police even, I think, hit the door of the home, that he had fled out of the home, Your Honor.
But do you have any evidence that he possessed the guns or drugs in the home?
From the pictures, you can see that there's a number of guns outside on the kitchen table. There were some guns.
Remind me where the machine gun was found.
The machine gun is actually downstairs, we believe, in the basement of the home.
Was there any evidence presented that Mr. Kendrick was like staying there as a residence, or just that he was there that day?
No, Your Honor. The evidence that we have is that he was present that day, and we believe that he had been present maybe a few days before.
But was there evidence presented he was staying there? She said no. I think 100% Yak Gotti gets found guilty. What do they have on Yak Gotti? Like, I don't think they have anything on Yak Gotti.
Kendrick being at the home, that he had knowledge of the drugs being present in the home, Your Honor. Specifically the marijuana, Your Honor, as well as the guns being in and around the home.
He's only charged with machine gun, right?
He's charged with the machine gun, and he's charged with possession of a firearm during a commission of felony with all the other guns that were found inside of the home, Your Honor. So he's charged both. That evidence, we believe that there's sufficient evidence to go back to the jury to show, at least for that count, participation in criminal street gang activity, given that evidence that has been admitted into evidence, Your Honor.
Your Honor, the state stood up here and gave a very thorough response to our motion for a directed verdict. But they never once, and I was listening very carefully, and you specifically asked them about the constructive possession. They never once made argument regarding any intent shown by Mr. Kendrick on possession of those drugs or guns. They made some arguments perhaps about ability, although even that I think was somewhat strained, where you have firearms that are in cabinets and closets and wherever, and he's just a guest in the home. The issue of intent is one, again, that you're going to instruct the jury on in the jury instructions. You also have a mere presence that you're going to instruct the jury on. So Mr. Kendrick, while he may have been present in the home, there hasn't been any evidence regarding intent, Your Honor.
Which is 100% true. No intent whatsoever. All right, we're back after like a 2-hour lunch break.
The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution, and doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged. So with regard to the motion for directed verdict on counts 1, 2, let me just do it this way. I'm denying the motion for directed verdict on all counts except I'm granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of, that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items.
Look at Yak Gotti's face. I think that's all pertaining to him. She granted certain counts. Let's see what they were real quick. All right, shout out Thugger Daily. Judge has granted defense motion for direct verdict of 3 of Yak Gotti's charges. Violation of the Georgia Controlled Substances Act, 2 of them, and possession of a machine gun. So she didn't think there was enough evidence for either of them.
That even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. Let me say that with regard to counts 2 and 49, again, is not a beyond a reasonable doubt standard that the court is required to employ in determining a directed verdict as to those counts. I understand the arguments. It is up to the jury to determine credibility of witnesses, and it's up to the jury to determine what witnesses or what parts of testimony they might believe and what witnesses or parts of testimony they might not believe. So if there is evidence presented that a jury chooses to believe, which is how I have to take it in evaluating this. I have to evaluate it as though the jury is going to believe whatever is most beneficial at this point to the state's case, which means they could believe everything that Mr. Copeland or Mr. Zachary said that would support the state's case. And frankly, they can disbelieve even an expert's testimony.
That's a huge W for Yak Gotti. Wait, someone said that Yak Gotti winks right here.
Let me say that with regard to counts one, I'm sorry.
Was that an intentional wink? Or is bro just tired? Remember they're waking him up early.
I am granting a directed verdict with regard to the greater of those charges on the 133. The state even admits they don't have all of the elements for that. So those will be charged as the lesser. It looks like that Martinez case provides that even over a defense objection, the state is entitled to get the lesser charge for those counts. So that's kind of, I guess, a grant of a partial directed verdict as to those counts. And those were well, y'all know which ones they were. I don't have them right in front of me.
That on number 6, it's committed an overt act on or after May 10, 2017, or
True.
within the applicable statute of limitations.
True.
Yeah, the only thing I'd point out is you got that clear.
I do.
And so, I mean, I agree it has to be somewhere. The question is where.
I mean, the idea with listing out the elements is when they're deliberating, they can go right to that and go, all right, here's what we need to be thinking about.
So Shar wants to add that, which makes complete sense. State even agrees about where they added in.
Within 5 years of the date of the indictment.
No, but let's
Right.
give them the dates.
Why not just give them the date? Why make them do math?
Yeah.
Nobody wants to do math here. We're all lawyers.
The calendar in my head.
And it's the same way that they have overt acts that predate the statute of limitations that they place in there. I'm sure they have good reason for that, but they could have additional things in there. So again, they're the ones that elected to place May 8th as the end date.
Not all of it. Some of it, but not all of it.
Those overt acts would be coming out of.
No, because Mr. Kendrick, I mean, if they determined there was a conspiracy and there were other conspirators, even if Mr. Kendrick wasn't the one guilty of any of these, somebody who might be a conspirator could have been.
The overt acts are still being sent back to the jury, even though she said there wasn't enough evidence for Yak Gotti specifically, for those specific overt acts that were found in Thug's house or whatever.
Again, I keep going back, we're giving them a long list of overt acts. And as lawyers in this courtroom, we're fully acknowledging that many of them, based on the date, cannot be that overt act. And we will not be back there to explain it to them. So I think
Well, we can explain it to them before we send them back then.
Well, right. And I think we need, my point is, with the jury instructions, I think we need to make that very
So we might want to add something. Many of the overt acts
Well, I was thinking,
listed occurred before.
I mean, yeah, anything to help the jury understand this better. There's so many overt acts, I think it was like 190 or something, 160.
commit an overt act, and then if we want to say within the applicable statute of limitations. But then
I'm not going to say that. That tells the jury nothing. I am going to say committed an overt act after May 10th, 2017, and I'm going to say it right in that list.
Yeah, I think that would be the best way to go, and especially because of how, even for attorneys, how complex this is.
Yeah.
That if you could walk them through that form in that fashion, that would be beneficial for all involved.
From the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. Moving on.
If I could just a second.
All right.
Paige wants to move on with this shit.
The need for naturally, but I believe that necessarily is an important word there.
I'm going to disagree with that. I think it should also.
Sharcy's going to disagree with his colleague.
We'll figure out the source of that language and come back to that as well.
May I go?
Oh, no, it needs to say a pattern of interrelated.
Well, it
racketeering.
doesn't need to say a pattern and interrelated, so I can just say a pattern of racketeering activity, because when we defined it, it has to be interrelated.
Well, then, if that's the case, could we leave in interrelated and get rid of pattern? If you only want one of those words, I prefer
I'm
interrelated.
fine with both of them.
Well, I am too, and that's my preference.
This is the concern I have, Your Honor, is we're drifting into the elements of 1614-4B and not C, because the state technically doesn't have to prove a pattern.
Well, it's not saying you do. It's saying you can consider any evidence that there might be. Mr. Floyd, it's from the jury instructions from the APS case, which you touted to be the standard by which we should all be measured. I think we're gonna.
Things evolved since then.
I think we'll be leaving that in there.
Yikes. So he cited that case earlier, saying it was like the best case ever for the language they use, I guess. Tried to fight something the defense wanted out or something, and he said it's literally in the case you've been citing here.
Mr. Atkins, didn't you submit that?
Yes, Your Honor.
Okay. All right.
I'm not the Your Honor.
Doug said, Mr. Atkins, did you submit that? He goes, yes, Your Honor. God, think about how much lawyers say the words Your Honor in their career. Holy shit.
I mean, as long as they're not inconsistent words, it doesn't matter. If they just further flesh something out, that's fine. So if you think they're inconsistent, point that out to me when we get there, preferably. But I don't think more words is worse. Frankly, most of this language is from some version of what the state wanted at some point. But I mean, I was kind of thinking it would be when we're talking about the verdict form, but yeah, I definitely don't want to be inconsistent.
understand.
That would be bad and confusing. Don't want to confuse, want to clarify.
I'm gonna be honest. If you can tell, I'm low energy today because this is tedious, man. Sitting through all this nerdy legal shit, trying to dumb it down. It's literally like 5 hours of this.
Engaging in a pattern of racketeering activity. What they're supposed to be determining is, did they conspire to engage in a pattern of racketeering activity? But the jury still needs to understand what a pattern of racketeering activity is. So how about pattern of racketeering activity means 1, engaging in at least 2 acts of racketeering activity, 2, within 4 years of each other, 3, in furtherance of 1 or more interrelated incident schemes or transactions. Explain what interrelated is.
I didn't mean to speak over you. I think that is easier.
Okay.
It flows better.
Yeah.
It actually flows better.
It does.
But even those federal cases say that the jury has to be unanimous on the types of acts that were committed. You'd agree with that, correct?
Whatever the jury's deciding, they have to be unanimous. I agree with that.
And
All right,
unanimous on the types
don't
of
talk
acts.
to each other. Got to
I'm
talk
sorry.
through me. That's just how it works in court. You know that. I know you didn't mean anything by it, but
I was-
sometimes.
Jury has to be unanimous, okay? Yeah.
As Mr. Steele might say, God forbid, a guilty verdict in this case, and an appellate court is reviewing, I think without some tiny level of,
Shout out Mr. Steele. God forbid.
I even hesitate to call this detail because it's so high level, but some guidance on the basis for the jury's verdict that it would be difficult to review. And also we would want to ensure that they are unanimous on the type. So if they indicate the type, that would ensure that.
But, here's my issue with type. I mean, so let's say they don't decide, or the jury doesn't think, oh, they decided they would murder every Paul. Let's say they decided, we're just going to hassle Lucci in any way possible. So we're going to steal things from Lucci, stab Lucci's mama. We're going to do X, Y, and Z. Those are different types of racketeering activity with the same victim. So it doesn't have to be the same type. And so that's the wrong word to say.
And it's the one that crept into the case law, but I think
Yeah,
our provision is
it's
correct.
wrong. And I'm sorry, I'm kind of like thinking through this as we do this because I've never done a RICO case before as a judge.
That's not surprising, by the way. She's never done one of these.
Of the predicate racketeering activity, and that's the 10th Circuit, and I believe they're agreeing with a number of other circuits.
Okay, so how about if we just say, would this work? Is this correct and sufficient? You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed.
That's acceptable to Mr. Kendrick.
Dude, that sounds so confusing, but whatever. Hopefully the jury understands it.
You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be permitted. What did I say?
Permitted.
Committed, sorry.
You know, I do have a problem with that.
Okay.
Because I think the jury is going to read that as they had to agree to commit specific acts. I know that's not what you're intending to instruct them, but I'm afraid that's what they're going to hear, and that's what the argument is going to get.
Then we can say,
It's kind of crazy how he basically just said, well, no, they're going to hear that and think that they had to agree to commit these crimes. RICO statute is just shit show. They're being very strategic about how they word this to the jury, but it might be above my pay grade, I'm going to be honest. Obviously, defense lawyers are trying not to instruct the jury on accident in a way that could make them lean towards a guilty verdict, so.
you must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts. To be unanimous on this count, you must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. You do not have to be unanimous as to specific acts. You must also be unanimous as to any overt act or acts committed to further a criminal objective of the conspiracy.
Will this jury be unanimous? Bro, this is going to end in a hung jury. Final prediction. Hung jury.
Such a complicated paragraph, if it might benefit just from a formatting perspective, if you broke it up the same way you did on page 1, where the different elements are on different lines.
For when,
Wrapped up in the statement of the criminal objective, which you've given them.
yeah, I know you think that. So thank you. What does the defense think? Do you think that survives appellate review as giving them the correct instruction?
You know, I may be right, I may be wrong, but that question is forefront of my mind in everything I'm saying.
Okay.
Yeah.
So he thinks this survives appellate review. I may point out, if my hair ever looked like this, it'd be time to shave it, brother. Like, what the fuck are we doing here? You have a landing strip on the top of your head. Shave it. Get rid of it. The dream of being young is gone. This angle has done him dirty all day. He's been standing here all day with the fucking landing strip on his head. Look at him picking up the mic.
My preference is more for the original language, but with the caveat that might actually go against me is that I'm just not entirely clear what participate in the enterprise means.
Yeah, me either, but that's the way the statute's written.
That sums up today. Not clear on what the participation of the enterprise means. The judge doesn't even know.
I mean, honestly, I think Mr. Floyd's might be more elegant. Original tracks the statute, and we're less likely to commit error by tracking the language of the statute. So I think that means we start closings on Friday, but we probably don't finish closings until Monday. And then I charge the jury, which I hope, I have no idea how long the charge is going to take, but I would think that the rest of the closing and the charge can be completed Monday. They get the case Tuesday. Well, at the end of the day, Monday, but I mean, they're not going to do anything in that little amount of time unless I talk really fast while I'm charging. They have a short day on Wednesday. They have a short day on Tuesday also. Oh, wait.
This is going to get really close to Thanksgiving, which means clearly the jury is going to put in a verdict before Thanksgiving on purpose, right? If I was on the jury, I'd be like, hey, let's try to get this shit done before Thanksgiving. Let's be free from this shit before Thanksgiving, please. We don't have to break and go to Thanksgiving and then come back.
Maybe it won't take them very long.
God, they do.
He said maybe it won't take them long.
Maybe it won't take them very long.
God, they do. These jurors, and I mean, they are trying to live their lives. I can't remember why we have a late start next Tuesday also.
I am very afraid of
I
closing.
consider doing all of this after Thanksgiving.
No, that's not what I'm asking. No, that's not what I'm asking. That's what the state says.
Wait. She said you're not considering doing all this after Thanksgiving, like the week after.
If we close and they take breaks and say we don't get a verdict back on Wednesday, you're going home talking over the Thanksgiving dinner. You're doing all of this, and you hope that they don't, but you don't know what.
I'm instructing them not to, and whether they have gotten the case or not, they're not supposed to be doing that.
I agree.
And
They're gonna talk about it at Thanksgiving, bro. I'm telling you. Some at least 3 or 4 of them talking about it with their cousins.
I'll get back to you.
We are.
Go ahead.
Stages are opening, closing on Friday morning.
Mm-hmm.
Myself and Mr. Weinstein close on Friday. Jury goes home for the weekend. Come back Monday, and then all they hear.
It's like the only thing they hear is the
So
stakes.
my proposal would be, I would ask if we could close on Monday. Whatever we don't get done, I don't believe it would be much on Tuesday, and then we could give the jury instructions Tuesday, Wednesday, and then they could come back after the break. And I just am very concerned about going for a weekend. And
Yeah, I mean, I agree.
That's a good point. So Monday could be closing, yeah.
I do like the idea for them starting tomorrow, and then we wrap it all up Friday. Or wrap up the closings Friday.
And you like that idea.
I do like that idea.
Only reason he likes that idea is because the jury charge won't be complete until tomorrow, and so you'll have all night to process and synthesize all the information that we'll continue to go over tomorrow.
Yeah.
Mr. Apate is not lying. It's my duty of candor. I have to tell you that.
I appreciate that, Mr. Weinstein, that you take your duty of candor seriously.
Very seriously.
All right, so closings Monday. Maybe we finish Monday. If not, then we come in late on Tuesday and finish closings, and then maybe we'll just have to see. I charge them either Tuesday and they get the case, in which case I probably just won't. I mean, are they going to deliberate for one day and then go to Thanksgiving?
I would say we could probably close and charge on Monday after Thanksgiving, and then they'll have.
Wait.
We can certainly not close and charge in one
sorry,
day.
not close. I meant
You
to
mean
say charge.
Tuesday?
Charge.
No,
On Tuesday?
On Tuesday.
But I think they should, if we charge them on Tuesday, I think they could begin deliberations immediately thereafter, correct?
Depending on what time it is.
We have court Wednesday, correct?
I mean, we're scheduled to have court on Wednesday. No, for the whole day.
They're going to deliberate the day before Thanksgiving? All signs are pointing to a rushed verdict here. What a disaster. Of course, this case ends with a rushed verdict. Ooh, he's recommending extending Monday and Tuesday to make sure there's...
That's the state's suggestion to keep them here till 7, just to make that clear.
I'm not staying here until 7 on 2 days, but... And then are you saying have them come deliberate on Wednesday and then take a long weekend and then...
Yes, Your Honor.
Okay. All right.
Dude, they could rush the verdict on Wednesday. 100% they could. But this is a very big case. I don't know if they would or not. It's going to be a hung jury, bro.
How about 10?
Oh.
All right, that's it for day 164. A lot of boring shit. I'm going to try to edit this the best way possible. Closing arguments start on Monday and finish on Monday, apparently. Finish maybe on Tuesday. She charges the jury, and then they deliberate on Wednesday. We are in the final stages, boys. It's insane. Hit subscribe. I love you guys. Thanks for the support. Peace out.